Welcome to another episode of the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. We're here to guide you through the complexities of family and divorce law in Ontario, Canada. I'm Deepa Taylor. Today, we're diving into a crucial topic that affects many separating couples: real estate implications in a separation. Before we get started, it's important to note that the information provided in this podcast is for general informational purposes only and does not constitute legal advice. I highly recommend consulting one of our lawyers by visiting DivorceLawyers.ca to discuss the specifics of your situation. Now let's get into it. When a marriage or partnership comes to an end, one of the most significant and emotionally charged issues that arise is what happens to the family home or other shared properties. Real estate, especially the matrimonial home, is often the largest asset a couple owns, and its division can be complicated. In Ontario, the law surrounding the division of property, including real estate, is primarily governed by the Family Law Act. But the intricacies can vary greatly depending on whether you were married or in a common law relationship, how the property was acquired, and whether it's classified as a matrimonial home. Let's start by clarifying what the matrimonial home is. In Ontario, a matrimonial home is defined as any property that was ordinarily occupied by you and your spouse at the time of separation. This could be your primary residence, a cottage, or even a condo that you both frequently used. What makes the matrimonial home unique in family law is that both spouses have an equal right to possess it, regardless of whose name is on the title. Now, this can lead to some common misconceptions, which we'll clear up. One of the most common misconceptions is that if one spouse brought the home into the marriage, they get to keep it entirely upon separation. Unfortunately, that's not the case. The law doesn't care who originally purchased the home or whose name is on the title. If it's classified as the matrimonial home, the value of the home at the time of separation is subject to division between both spouses, regardless of who paid the mortgage or contributed to its upkeep during the marriage. This can be a sobering realization for many. Imagine you bought a house 5 years before getting married, and you've been paying the mortgage alone. You might think you're entitled to that investment, but legally it's considered part of the marital assets once you tie the knot. But what if the home was inherited? This brings us to another key point: inheritances and their impact on property division. Generally, inheritances are excluded from property division. However, if you use that inheritance to purchase a home that you and your spouse live in, it can become a matrimonial home, and thus subject to division. The rules differ significantly when it comes to common law relationships. If you're in a common law relationship in Ontario, the property division rules are not the same as they are for married couples. Unlike in a marriage, there's no automatic right to an equal share of the property for common law partners. Instead, property is divided based on ownership. Let's say you've lived in a house owned solely by your partner for 15 years. If you separate, you don't automatically have a right to half of that home. However, you might have a claim if you contributed significantly to the property, either financially or through labor, and can prove unjust enrichment. These claims, known as trust claims, can be complex and require substantial evidence to succeed. This is where having a cohabitation agreement can save you a lot of trouble. A cohabitation agreement, much like a prenuptial agreement for married couples, outlines how property and assets will be divided in the event of a separation. It's a tool that provides clarity and can prevent lengthy legal battles. Now let's move on to the actual process of dealing with real estate in a separation. One of the first decisions you'll need to make is whether to sell the property or if one spouse will buy out the other's interest. If you both agree to sell, the process can be straightforward, although emotionally taxing. The property is listed, sold, and the proceeds are divided according to your agreement or the court's order. However, if one spouse wishes to keep the home, they would need to buy out the other spouse's share. This requires a fair market valuation of the property, often by a neutral third party, to determine the buyout amount. Disagreements can and do happen, especially in a hot real estate market where timing the sale could significantly impact the value. If one spouse is resisting the sale, the other may need to seek a court order to force the sale. This can be a lengthy and expensive process, so it's always advisable to try and reach an agreement out of court if possible. Let's talk about equalization payments. In Ontario, when married couples separate, they are entitled to an equal division of the net family property. This means that each spouse is entitled to half of the total value of the assets accumulated during the marriage, minus debts. The matrimonial home plays a significant role in this calculation, because it's included in the net family property without any deductions for what either spouse brought into the marriage. It often represents a large portion of the assets to be divided. This is particularly true if the home has appreciated significantly in value. If you're the spouse who is keeping the home, you may need to make an equalization payment to your ex-spouse to balance out the division of assets. This is where things can get complicated, especially if other assets are tied up in the home or if there is a large mortgage or line of credit attached to the property. Cottages and vacation properties add another layer of complexity. These properties can sometimes be considered a matrimonial home if they are used regularly by the family, meaning they would be subject to the same division rules. However, if a cottage was inherited by one spouse and kept separate from the family's general assets, it may be excluded from division. But if both spouses contributed to the upkeep or mortgage, the other spouse could potentially make a claim. The emotional attachment to such properties often complicates negotiations. It's not just about the financial value, it's about the memories and the desire to maintain continuity for children or to keep a cherished family tradition alive. Navigating the division of real estate in a separation is rarely straightforward, which is why it's crucial to work with professionals. Real estate agents, property appraisers, financial planners, and of course, family lawyers all play essential roles in ensuring that the process is handled fairly and efficiently. A financial planner can help you understand the long-term implications of selling or keeping a property, including tax considerations and the impact on your overall financial health post-divorce. Meanwhile, your lawyer will ensure that your rights are protected and that any agreements you reach are legally binding. In conclusion, the division of real estate during a separation is a complex and often contentious issue. It requires a careful understanding of the law, a realistic assessment of your financial situation, and, when possible, a willingness to compromise. Remember, the goal of the separation process is not just to divide assets, but to lay the groundwork for your financial future. Working with professionals and approaching the situation with a clear mind will help you navigate this challenging time more smoothly. If you're facing a separation and are unsure of your rights or the best course of action, I strongly encourage you to seek legal advice. At DivorceLawyers.ca, we're here to help you through every step of the process. Thank you for joining me today on the Divorce Lawyers podcast. I hope you found this discussion on real estate implications in a separation helpful. If you have any questions or topics you'd like us to cover in future episodes, feel free to reach out. Until next time, take care, and remember, knowledge is power when navigating the complexities of family law.